Hello, and thank you for tuning in to the Beyond Hourly podcast hosted by Omni Bridgeway, one of the world's most experienced dispute funders and enforcement specialists. Our podcast focuses on commercial disputes around the globe and innovative ways to maximize value for clients and law firms. Episodes of this podcast can be found on our website at www.omnibridgeway.com, iTunes, Spotify, and other podcast networks. We welcome you to subscribe to the podcast and leave us reviews. My name is Justin McClernand, and I'm your host for today's podcast, Investment Treaty Arbitration and Dispute Resolution Finance. I'm an investment manager based in Omni Bridgeway's Perth office. In this podcast, my colleague Nathan Landis chats with our guest, Nick Gallus. Nick is a special counsel with law firm Lipman Karas based in Adelaide. Nick has extensive experience representing states and multinational companies in investment treaty and commercial arbitrations, WTO disputes, and treaty negotiations. He has advised clients on a broad range of international disputes, including in the resource, energy, and construction sectors. Nick also lectures in international arbitration at Monash University in Melbourne, and previously taught international trade and investment law at Queen's University in Canada. Nathan Landis is an investment manager with Omni Bridgeway based in Perth. Nathan was previously a barrister in Western Australia, and prior to that was counsel at global law firm Clifford Chance, where he worked on large commercial disputes, international arbitration matters, and cross-border litigation matters. Nathan is a member of the Chartered Institute of Arbitrators and has appeared in a range of courts and tribunals in Australia and the Middle East. In this podcast, Nick and Nathan will discuss a range of issues relating to investment treaties between states and other entities. In particular, the types of disputes that arise under investment treaties and the role of international treaty arbitration to resolve these claims. Welcome, Nick and Nathan.
Thanks, Justin. Nick, could you please start by telling our listeners a little background on your career in the law before joining Lipman Karas?
Certainly, and let you start by thanking you for inviting me to join the podcast, Nathan.
Sure.
Before joining Lipman Karas here in Adelaide, I was in Paris with the arbitration boutique Three Crowns, working on a mixture of commercial arbitration and investment treaty arbitration. And I should say, representing both claimants and governments as well. And before that was working with the Canadian government as counsel in investment treaty disputes, as well as WTO disputes, and also helping the Canadian government to negotiate investment agreements and trade agreements, including the comprehensive and progressive Trans-Pacific Partnership, which took up a lot of my time there.
And a bit of a mouthful to say as well.
It is. Unfortunately, the acronym is also a mouthful, the CP TPP. So whether you're saying the full name or the acronym, it's hard to get out.
Well, over the last 30 years, Australia's steadily entered investment treaties with states and other entities. These treaties promise a certain level of protection to investors from the other country, including that those investors can claim compensation before an independent arbitration tribunal if they feel that promised protection was not provided. Firstly, can you tell us how many of these treaties there are worldwide and how often disputes arise?
I think now there are over 3,000 of these treaties, mostly are bilateral treaties between two countries. Mm-hmm. There are also some multilateral treaties, including the CP TPP that we talked about before. As for disputes under these treaties, I think we're almost 1,000 disputes now. And of those 1,000 disputes, they've generated hundreds of awards, including some big awards for claimants.
Sounds good. Can you tell us about the largest ever investment treaty, which I believe we've already mentioned, but entered into the force at the end of last year?
I'm not sure if it's the largest investment treaty. There are big treaties, for example, the Energy Charter Treaty, which has a lot of signatories and has an investor-state dispute settlement mechanism. The CP TPP, which we talked about before, certainly one of the larger agreements governing economic relations for all the countries. There's I think 30 chapters there governing everything from investment to electronic commerce to intellectual property. And the investment chapter with 11 signatories makes it one of the bigger investment treaties and certainly right up there with the Energy Charter Treaty.
Yeah, and that's both in terms of the number of countries that are involved as well as the economic activity that those countries are involved in.
That's right. The signatories include Japan and Canada, big G7 countries. Initially, it was negotiated with the United States, which would have made it an even bigger treaty. After Donald Trump was elected president, the US pulled out. And so its scope became a little bit smaller. But perhaps, who knows, in the future, the US may join again and it may become a treaty of even bigger scope.
They might make the treaty great again.
Well, the treaty's already great, but perhaps they'll make it even greater.
Now, I understand you had a role in the negotiations of the CP TPP. Can you tell us about that role?
Yes. So while working with the Canadian government, was counsel for the government in the negotiations over the agreement. That involved several chapters, including the investment chapter. That involved participating in the negotiations, giving legal advice, and helping to settle the final text of the investment chapter of that agreement.
Lots of meetings and lots of coffees.
Lots of meetings, lots of coffees, and lots of travel. Because it was a Trans-Pacific partnership and we were coming from Canada, a lot of the travel was to countries on this side of the pond. And the final stages of the negotiations, that travel was every month. So it was a lot of travel at a time when I had small children and therefore a very upset wife.
But you seem to have gotten through to the other end okay.
We did get through okay, yes.
Now, Australia's entered into these sorts of agreements with other countries before, and I think you mentioned the Energy Charter Treaty, which, although we have signed, it's not yet ratified. But the CP TPP is significant for a whole other range of reasons. Can you expand on that?
Significant for the countries that are a party to the treaty, and in particular countries that have now agreed to investor-state dispute settlement with Australia. In particular, Japan and Canada have now agreed to investor-state dispute settlement with Australia. And that's significant because Canada and Japan are two of the biggest sources of foreign investment into Australia. Japan's in the top 5 and Canada's in the top 15. Canada is particularly important for this area because a lot of the investment of Canadians into Australia and of Australians into Canada is in the resource sector. And typically, as you know, that's where we see a lot of the investment treaty claims.
Yeah. And can you describe some of the investments that, say, the Canadians have in Australia and vice versa?
Yeah, certainly there are some big Canadian investments in Australia. Barrick has a big gold mine, I think, in your part of the world, Nathan.
Yes, that's right.
We know that there are certainly a big Canadian gold mine also operating in Victoria, Kirkland Lake Gold, and there are others as well. And there are also a lot of Australian companies operating in Canada, including BHP, I think, has a big mine in Quebec.
Yep, and Woodside, my part of the world as well, has a fairly large investment in LNG in Kitimat.
Right.
Also in Canada.
Okay.
When we're talking about the investments in the resources sector, why are investment treaty protections so important?
The main reason that they're important is that often in the resource sector, you have companies that have as their only asset the mine that they're operating, and resources are often a politically sensitive issue for a country. And so when a government is elected who is choosing to either nationalise its resources or focus more on locals rather than foreigners, what often happens is that the country will interfere with a foreign investment in the resource sector and sometimes will wipe out that investment completely by expropriating the mine. And in those circumstances, the investment treaty claim can often be the last resort for the investor, claiming the damage inflicted by the government interfering with the investment can be the last chance for the investor to recoup their investment in some circumstances, claim the profits that they would have earned through the investment.
So there's been a number of successful investment treaty claims in the resources sector which address some of the issues that you've just identified. Are you able to give us an example of one of those claims?
Certainly, yes. It seems like every couple of months now there's a big award in the resources sector. The one we were talking about just before has got a lot of headlines. The successful claim by the Australian company who was operating in Pakistan,
yes,
and who was denied a mining permit after the tribunal held, being told over several years that mining permit would be awarded. And the tribunal found that by denying the company the mining permit at the end of that process, that Pakistan had failed to act consistent with the obligation to provide fair and equal treatment and had also expropriated the investment, and as a result, the tribunal awarded the Australian miner over $8 billion, I should say. That's a recent headline where a mining company has secured a big win under an investment treaty, but there are several others over the last couple of years.
And that claim, or the underlying dispute that led to that claim, that seemed to also encapsulate some of those political issues that you talked about earlier.
Yeah, I wasn't involved in the case, and so I can't speak from personal experience, but reading the award, it seems that the miner over several years had a very good relationship with the local government, which is often critical for success in these areas.
Yeah.
And that at some point the local provincial government decided that it wanted to operate the mine, and therefore ultimately it denied the permit. And as a result, the miner turned to the treaty and successfully claimed compensation.
So there's been a lot of investment treaty claims between developed countries with sophisticated regulators who nevertheless breach their treaty obligations. It's not just a case of investors from the developed part of the world investing in developing parts of the world and finding the sorts of political issues that you mentioned earlier. Can you give us an example of some of the claims that have taken place between some of the developed countries?
Yeah, there are many examples and many high profile. The famous case here in Australia is the case brought by Philip Morris against Australia. And whether you call Philip Morris an American or a Hong Kong company, which was controversial in that dispute, they're both investors from sophisticated countries investing in a country like Australia, a developed regulatory system. From personal experience, a lot of the cases that I've dealt with have been defending the government of Canada against claims by American investors. Indeed, of the 40-odd claims under the North American Free Trade Agreement, of the 40-odd claims under the North American Free Trade Agreement against Canada, almost all of them were by US investors, where, as you say, you had investors and respondents from sophisticated regulatory environments, nonetheless resolving their dispute through investment treaty arbitration.
As a funder, I've been involved in a number of international arbitrations, both in the investment and the commercial arenas. These cases are always complex, and with their complexity comes expense. Consequently, parties are increasingly seeking funding to fund these claims. In particular, as you mentioned earlier, that these are generally companies who have single assets or a small number of revenue-producing assets in the other country. And when there's a problem with that asset, they're either taken away through expropriation or they're otherwise impaired in how they're able to generate revenue for that company, then that creates a problem for the company in terms of its cash flow. Nick, can you give us an example of a funded treaty claim?
Yeah, I can give you a few. I should say up front that I personally haven't been involved in funded treaty claims, largely because a lot of the treaty claims I've been involved in have been on behalf of governments who typically don't use funders. But in the headlines over the last couple of years, there have been many successful claims by investors who, for example, lost their investment in Venezuela after the Venezuelan government decided to nationalise resources there. A lot of those successful claimants were Canadian mining companies. Perhaps the most famous example is Crystalex, who were awarded well over $1 billion after a tribunal found that Venezuela had breached its obligations in an investment treaty.
And Crystalex is a good example of the profile of that company I was talking about earlier, where Crystalex had their primary asset in Venezuela, and once that asset had been nationalised by the Venezuelan government, Crystalex found itself in a problem in terms of its cash flow and its ability to pay for the steps that were required to enforce their rights.
Yeah, you see that all the time. For example, we were talking before about what's going on in Tanzania at the moment, and putting aside whether or not what Tanzania is doing is a breach of its investment treaty obligations, what you're seeing is that a number of companies have been wiped out by what's happened in Tanzania, and they're reaching out to funding companies and saying we simply don't have the resources to obtain justice any other way.
It's been a pleasure to talk to you today.
Thanks for having me.
That brings us to the end of our podcast today. Thank you very much to Nick Gallus for being our guest on Omni Bridgeway's Beyond Hourly podcast and sharing his knowledge with our listeners. As I mentioned at the outset, episodes of the Beyond Hourly podcast can be found on our website, www.omnibridgeway.com, and also by iTunes, Spotify, and other podcast networks. And I invite you to subscribe and leave us reviews. You can also access a transcript of this podcast on our website blog page. Please feel free to follow up with me, Justin McClernand, at jmcclernand at omnibridgeway.com for any feedback, ideas, or insights you have on topics we should cover on our podcasts. We'll be back soon with another episode. Until then, thank you for listening and goodbye.